The decision that people commonly refer to as the Gomez decision is a decision that was made by the state Supreme Court in Minnesota in 1995. The state Supreme Court ruled that the ban on Medicaid funding for abortions was unconstitutional, and that it was unconstitutional for the state of Minnesota to offer, on the one hand, all of a woman's prenatal care, postpartum care, delivery costs, etc., but not to offer payment for her other legal option, which was an abortion. And so they figured that that was an imbalance and it was unconstitutional to not fund all of her legal options. The Gomez decision is interesting in Minnesota because it has been referenced in other precedent by other states, from everything from anti-sodomy laws to other privacy-related issues, where Gomez has been cited as precedent and has been part of the case. And so what we have now is a situation where in Minnesota we join, I believe it's 16 or 17 other states that have Medicaid funding for abortion. The state constitution of Minnesota has what you would call kind of a broader interpretation of the right to privacy, etc. In the narrative of the decision, the court said that reproductive freedom in Minnesota is a fundamental right. And so many people refer to the Gomez decision as sort of being Minnesota's Roe versus Wade. And it said that under the state constitution, the women of Minnesota have a broader right to privacy, and that their reproductive freedom, their actually decision regarding reproductive rights and their decision regarding whether or not to terminate a pregnancy is protected under the state constitution. With Gomez being kind of a determination of fundamental reproductive freedom, as well as access to abortion through Medicaid, the Minnesota Citizens Concerned for Life and some of their allies are always trying to overturn the Gomez decision. And there's really basically two ways to overturn a state Supreme Court decision. You can either get an amendment made to the state constitution, which is difficult to do. The other way they can do it is they can pass a law that's basically unconstitutional. So they can pass a law that, for example, says the state shall allocate no funds for abortion. And they can pass that law, get it signed by the governor, and then of course we would be obligated to challenge it in the courts because it's an unconstitutional law, thus giving the courts another opportunity to rehear the case. The other scary thing about it is that when judges, if they ever rehear the Gomez case, or any case on abortion, they will also be quote-unquote on record on abortion, which does give the MCCL another opportunity to run then candidates and run against judicial candidates and to sort of inflame the ideology of our judicial races. To date, we have stopped all of those efforts. They've come close several times. I think really the closest that they really came was in 2006, so just recently. The MCCL had a very active and very alarming bill that they called the Abortion Regulation Act, and it had several parts to it, but one of the parts was a ban on state funding for abortion, which again would have been unconstitutional, and we would have had to file a case with the courts, and we would have had the courts rule up or down basically on Gomez. It is paramount to the equality of all Minnesotans that they have at any time in their lives basically all the options available to them to choose from. It should become part of our legacy that we always will have a legislature that supports a woman's right to choose.